Good afternoon, everybody. Welcome to our panel discussion on net neutrality. I'm Ed Felton. I'm the director of CITP and a faculty member in computer science and the Woodrow Wilson School. We like to hold these sorts of panel discussions on current events in technology policy. This one is a little bit delayed from the FCC action that triggered it because of the holiday break. But now that the students are back in campus, this is a good time. So let me first briefly introduce the panelists. I'll give then a little bit of a summary of some of the history, why we're here, and what it is that's happened recently of interest. And then we'll ask each of the panelists to make some introductory remarks, and we'll open it up for some discussion. So first, let me introduce the panelists. Nearest to me here is Tithi Chattopadhyay. She's the Associate Director of CITP. She received her PhD in economics from Michigan State, working in the Quellos Center there. She managed broadband policy for the state of Wisconsin for a while, and also has worked on technology and economic development for local governments in New Jersey and elsewhere. Next, we have Henning Schultzrin. We're very pleased to have Henning journey here from Columbia University, where he's a professor of computer science. He also served as chief technologist at the Federal Communications Commission for 2 stints, one in 2012 to 2014, and then again in 2017. So he has firsthand experience with this issue. And then last but not least, Nick Feemster, who's a professor of computer science here and deputy director of CITP. Nick is an expert on networking, security, network management, and internet measurement, among other things. Let me talk a little bit about the events, recent events that have triggered this discussion. On December 14th, the Federal Communications Commission, the FCC, decided on a 3-2 vote, vote on party lines, to reclassify the regulatory status of home internet service. This was described as a repeal of net neutrality regulations. Soon thereafter came a flurry of lawsuits that have been filed or will be filed by private parties or by state attorneys general. And these lawsuits mostly challenged the FCC's legal authority to issue the order or to issue it in the way that they did. On Friday, a group of big companies that provide services over the internet, the group includes Facebook, Google, Netflix, and Amazon, announced that they would join the legal fight to try to block or rescind the FCC order. And then just today, a group of 30 senators appear to have forced a vote in the Senate on the FCC's action. It's a vote on a resolution that would overturn the FCC's action. So although it's seen as unlikely to overturn the action, this would require every senator to be on record as supporting or opposing the FCC's action. So let's step back and do a little bit more background on what net neutrality is and some of the history that got us to this point. The term net neutrality was coined by Tim Wu, who's a professor at Columbia, in 2003. The idea was that residential internet service providers, or ISPs, that is companies like Verizon and Comcast that provide internet service to the home, that those should not discriminate against different types of internet traffic, nor should they charge a toll to service providers in exchange for carrying their traffic to consumers. The idea is that internet service providers are residential ISPs are perfectly welcome to charge home consumers for their use of the internet, but they shouldn't put differential charges on services like, say, Netflix or Google for access to consumers. And that residential ISPs should not discriminate against different types of traffic. This grew out of a past notion that has a long history in telecom policy of common carriers. Common carriers was the status that applied to traditional landline phone companies going way back. Historically, these companies, of course, were regulated monopolies. They were not required to police the content on their networks. But similarly, they were also required to carry any lawful, non-damaging traffic without discriminating among that traffic. So they couldn't block you from sending whatever lawful audio you wanted to send over phone lines, nor could they charge you different prices for different types of conversations that you wanted to have. So the FCC enforcement of neutrality principles with respect to internet service goes back many years. One early example was in 2004 when the FCC fined a small internet service provider called Madison River Communications. They were fined $15,000 by the FCC in 2004. Madison River had restricted their customers' access to Vonage, which was a voice over IP service that might substitute for phone service, and Madison River was in the business of selling phone service. But the FCC said that they were not, Madison River was not entitled to try to block or restrict access to a lawful internet service like Vonage, even though it competed with Madison River's other home phone product. For many years, net neutrality was more of a principle than a fixed rule. But more recently, in 2015, the FCC reclassified the regulatory status of home broadband, putting it into what's called Title II, which is a type of common carrier type of classification. And the FCC then, subsequent to that reclassification, issued a set of net neutrality rules. So it was this reclassification and set of rules from 2015 which the FCC recently overturned with their order in December. So that brings us up to the present. There's a couple more concepts that I want to put out there and contextualize that I know are going to come up in the discussion, which are also relevant to net neutrality. The first of those is what's called zero rating. Zero rating is when an internet service provider says that certain kinds of services don't count against your bandwidth charge or don't incur a fee. For example, if your mobile carrier says that you pay for bandwidth, but we don't charge you for, say, Netflix bandwidth, that would be zero rating. And that's an example of something that's often discussed in the context of net neutrality, because that zero-rated service is treated differently from other services. We also may hear discussions about peering. Peering is what happens when different internet service providers or internet service providers and large internet companies connect their networks to each other. Preferential peering would refer to a residential ISP, internet service provider, giving one internet service provider, a lower price for peering than others, or a faster connection. So for example, in 2014, there was a spat between Comcast and Netflix. Netflix thought that Comcast was deliberately throttling Comcast users' access to Netflix in order to get Netflix to pay a higher fee for their connection to the Comcast network. Comcast said something else was going on. The end result of this dispute was a new agreement between the two companies in which Netflix paid a higher amount to Comcast. So that notion of preferential peering and the idea that internet service providers might potentially try to set up a toll booth between their users and internet services is also one of the things at issue in net neutrality. So with that background, let me turn to the panelists, and I'll call first on Nick.
Okay, great. So thanks. I'll talk about a few things in my comments. One is what next? What might we expect? And for that, I'll talk about, are there other places in the world that sort of give us some hints about what might ensue in an internet where these net neutrality rules are not in place? There are a lot of places where we might get some hints as to what might happen. The second question I'll talk about a little bit is, was the internet really neutral in the first place before the so-called repeal? The third question is how content providers might react, technically, economically, and otherwise. And then if time permits, or perhaps throughout the panel, I think another topic that might be worth talking about is this notion of prioritization. When computer scientists and network engineers use the term prioritization, it's distinct from paid prioritization. When lawyers use the term prioritization, they mean paid prioritization. So those two are not necessarily the same thing, and we can if that comes up later, we can tease those apart. So over the past decade, I've worked a lot on technologies that study the performance of internet access links on both fixed and mobile broadband networks, both here and in other countries, including many parts of the developing world. More recently, we've been studying how those underlying network factors like throughput, packet loss, latency, and a lot of network performance jargon terms relate to the things you might care about, like what does my Netflix stream actually look like, and is it rebuffering, and so forth. That's a more complicated question. In addition to studying the performance, we've also studied things like how pricing affects user behavior. So Ed mentioned the term zero rating. So we've looked at, when a carrier practices zero rating, which is actually quite common in other parts of the world, how do users respond? And actually about 5 or 6 years ago, we also looked at this concept of how a tiered pricing model would affect ISP profits. So the notion that one ISP might pay another provider different rates depending on where those traffic flows are going or how much traffic it's sending is something that actually many people don't know, but is already taking place and has been taking place for almost a decade now. So first, the question of what might this non-neutral internet look like? Well, there are already many parts of the world where the internet is not neutral. One of those places is South Africa. Another is Kenya. A couple of things that we looked at there are what mobile carriers commonly do in those countries. Ed mentioned the practice of zero rating. One of the things that the carriers will do to compete with one another is offer zero-rated service. So, for example, there's an African mobile provider called MTN that offered a promotion where they zero-rated Twitter. They basically said you can use as much Twitter as you like, and it won't count against your data usage fees. And this is significant.
Impact on mental health was not accounted
Yeah,
for.
they did not talk about that. But this is significant in these countries because mobile costs are very high. What we found in that study, there are a number of instances of this. That was just one example. Other popular apps that are zero-rated include WhatsApp and video in some cases. So what you might expect, users, of course, tend more towards those apps, right, and more towards those providers as those promotions take place. But often those tendencies are not sticky, so that when the promotion ends, the usage doesn't stick. That being said, another thing that we found through a survey of users in those countries is that users tend to still prefer the, quote, full service application. So another example of zero rating is Facebook offers something, you may have heard of it, it's called Free Basics. It's basically a walled garden type service where you can use as much of the apps that Facebook sanctions, including their own, within the context of their walled garden app. And if you go outside of that app, you're basically going to pay the regular data rates. And the study found that users tend to basically not like that. They tend to still prefer their full service versions of news applications, et cetera. And they, by and large, are using these zero-rated offerings like that as a means of conserving data. Like, data is very expensive, and as I'm running up against the usage cap, I'll switch to the free thing. But I still, I'm going to the extent that I can afford it, use the other. So I think that being said, right, and that particular example points to a concern, however, that these walled gardens are being created, right? Even that example I just presented suggests that people will tend towards the free thing, they'll tend towards the walled garden where a particular content provider is controlling the information and content that a user might be able to access. And a potential concern there is that certain content providers could gain an upper hand and use market dominance to create various kinds of levers. They may use them to maintain their market dominance, and that's potentially a cause for concern. The other, I think, cause for concern is that those may become levers for internet censorship and control. So if you can imagine that in certain countries, users view Facebook as their gate to the internet, and now all a government or an entity needs to do to control users' access to information is to go pull the lever on a content provider, then I think we should certainly be concerned about that kind of centralization that may result in a non-neutral internet. This is more than just a hypothetical. There was one survey that was conducted in many African and other developing countries where people were asked, do you use the Facebook and do you use the internet? And more people said they used Facebook than said they used the internet, which gives you an indication of people's perception of what the internet actually is. But we've already seen these kinds of moves taking place with hosting companies. Recently, there have been examples of content distribution networks like Cloudflare making decisions about content that they will or will not host. So that's one example of a decision that a hosting company has made to block content. This has also been done in the commercial sector. Recently, Google blocked YouTube access from certain Amazon Echo and other Amazon streaming devices. So content and information is already being censored for political, commercial, and other reasons, even right here in this country. And I think that certainly remains a cause for concern. As content providers gain the ability to solidify their incumbency and upper hand, we should be concerned not just about the ISPs blocking, but also the content providers pulling levers. This brings me to my second point. Was the internet really neutral in the first place? So I think that's something that maybe the panel can discuss at greater length. But I think one of the interesting, I'd say, glossing over in the open internet order is that content distribution and caching networks are sort of pushed aside, right? So we talk about paid prioritization as something that a router might do or a peering, an interconnect might do. I prefer this traffic over this other traffic. And if I'm Comcast doing this to Netflix traffic or doing it against Netflix traffic, we can think about which packets get to go first. But that's a different question than Netflix deciding or being able to say move its content into Comcast network to move its content closer to users, effectively putting the servers inside of the ISP network. Whether or not a content provider gets to do that is really at the discretion of the ISP, and for a long time Comcast was not allowing Netflix to do this, and recently they've actually begun cooperating more and more. So you might wonder, a lot of the discussion about the repeal of net neutrality is like, am I basically going to, see crappy Netflix performance? I think your Netflix is going to be just fine because Netflix is one of the big players here. And it's really the smaller, content distribution and services that we may need to worry about who don't have those levers to pull where they can place large caches of videos content inside an ISP network to gain that kind of upper hand. Third question was how content providers might react technically, economically, and otherwise. So I think I'll preface this by saying I'm not an economist, but one thing that we looked at about 5 years ago was what kinds of effects tiered pricing might have on ISP profits. And this was done basically recognizing the fact that large content providers like Google were already paying their transit providers differential pricing based on the types of content that they were serving across the networks that eventually hit the customers. To give you a motivation for this, it costs more to transmit certain types of bits to certain parts of the internet than others. It costs more to send bits across the Atlantic than it does to send bits to a server in the same building. And the question that we were asking at the time was, well, given that there are these differential costs, and given that ISPs are already paying these tiered pricing that reflect those differential costs, what are the sort of pricing models that make sense, and what kinds of effects on ISP profit might ensue from different kinds of pricing models? And what we found in that work is that the economics suggest that an infinite number of tiers basically will lead to an efficient market. Obviously, that's going to be really complicated and be very hard to understand and account for. But the good news there for ISP profit, if that's something that you care about, is that 3 or 4 tiers is kind of enough to basically milk most of the efficiency out of that market. And that actually you need to consider both the costs of transferring those bits as well as the volume of demand. So I won't get into the details of that study, but just to say that that was done in the context of transit, which is different than access, but
so let's stop. Talk
Okay.
about quickly about the distinction between transit
yes.
and access.
Okay, so transit, when we talk about transit, that's basically two large internet service providers or two large providers like Netflix and Comcast connecting to one another. And we'll talk about interconnection or peering or transit as the act of moving those bits from one of those networks to the other. That would be distinct from you paying Comcast for access to the internet. Okay, so we
And
studied...
net neutrality is about that endpoint. It's about the residential connection.
It's a little bit of both.
Yeah, so it just gets more complicated. Yeah.
I'll wrap up on that point.
Thank you.
It's somewhat on the access, but also one of the things that the ruling last Friday said was, actually we're not going to touch the interconnect. There was a big question as to like whether we are going to regulate between Netflix and Comcast, and the answer there was no. Okay, so let me come to that. So what's going to happen there? One is that we might start to see some of this differential pricing more, both, I mean, we're already seeing it at transit. We might start to see it at the access network. I don't know what's going to happen if we start to see it at the access network, but I predict we may start to see some of that. There's some precedent to suggest that, and the order from last week they make the claim that, hey, prices might drop at the access network. Unclear whether or not that will bear itself out. The opposite did happen in the Netherlands in 2011 when KPN Quest was prohibited from doing usage-based pricing, and they responded by raising flat fees for everybody. Last point I'll make is directly to your distinction of access versus transit. So how might the content providers react technically? Well, with the sort of lifting of the threat of, hey, we might touch the interconnect, now that gives these guys a lot more flexibility and leeway to do other kinds of things, as they interconnect. So we might start to see things like peering for specific applications, or prioritization or paid prioritization for certain types of content at the interconnect. That's something that we worked on actually in the context of software-defined networking as applied to IXPs. And technically that idea has gained a lot of traction, but at the time there was like quite a bit of reaction to say, hey, wait a minute, IXPs aren't supposed to basically treat certain kinds of bits as more important than others. And I think now that kind of sort of threat of regulatory action has been lifted at the IXP, that we might start to see the technology push more creative peering arrangements forward. So I'll end there.
Great. So let me pass to Thea next.
Okay. Given my background in economics and having worked on the rural side of broadband access and things like that, I thought I would sort of focus on that simply because I know a lot of the technological aspects and the legal aspects might be covered. But one of the other reasons why I wanted to focus on that was one of the big reasonings of sort of reclassifying or moving from Title II to Title I, or at least in the order, they sort of economic reasons were cited as one of the biggest justification for moving from Title II to Title I. So I thought it might be interesting to talk about the economic reasons from both the proponents of net neutrality from their perspective, as well as the opponents of net neutrality, or rather reclassification into Title I from Title II. So the first argument that was made, and I'm going to try to represent both sides the best I can, the first one was that after the 2015 order, they found that there was a drop in CapEx, in broadband investment or capital expenditure. And this could have happened, I mean, of course, this was one data point, but the reasoning behind this based off of the order last week was that there were higher enforcement costs to rural and rate of return providers. Rate of return providers are usually your smaller providers. They're your incumbents, but your smaller providers in rural areas and not your price cap providers. And there needed to be some flexibility for these rate of return providers to actually use tiered service, what Nick just talked talked about, or even other volume-based charges to sort of recover those costs and pass those costs on to content providers and not consumers. So that was one argument. The other argument was the higher costs of enforcement that these rate of return carriers face. And those higher costs of enforcement sort of deter them from actually investing more. So that was another argument. And finally, the third argument is the fact that you probably won't even see any innovative services that these providers might have been planning, whether it's zero-based offerings or other market-sponsored offerings, because they're afraid to invest under a period of regulatory uncertainty. So that was the other reasoning. Now, on the other side, the people that are proponents of the net neutrality argument or the light touch Title II classification argument find that there is really...
So hang on, can I stop you
Yeah.
for a minute?
Yeah.
Light touch Title II means that there are net neutrality regulations, but they are relatively mild?
So the light touch Title II is basically they impose the common carrier, and you can sort of correct me if they impose the common carrier sort of in a light touch way, where they did not impose the rate of returns. There was no tariffing. Like in the original Title II for the telephone companies, there was tariffing. There was sort of a requirement to unbundle the network elements and things like that. But this was more a light touch only from the point of view of making sort of not blocking, not throttling, not allowing paid prioritization without those other regulatory sort of, requirements of sort of, sort of price regulation and things like that. So that's the difference between the light touch Title II and the actual Title II that was
I'll get
imposed
into that a
on,
little bit.
imposed on the telephone companies before. So of course, the proponents of net neutrality claim this is only one data point. So it was only between 2015 and 2016 that you saw this $1 billion reduction in investment. Of course, there is no actual filing with the SEC to actually support the drop in telecom capex claim. And there are also other macroeconomic reasons that probably were that existed because they also witnessed an overall reduction in capital expenditure between 2015 and 2016, which might suggest there are other macroeconomic reasons, and therefore it's not sufficient evidence to say that the 2015 order sort of resulted in the drop of capital expenditure by the telecom providers. So that was one thing. The second thing that I wanted to get into was actually the classification of the Title II classification, or classification as a public utility. The opponents of the Title II classification sort of seem to suggest that internet does not resemble public utility or public utilities like water or sewer or electric utilities that are regulated, that are rate regulated. Telephone used to be rate regulated, and the big difference is that those basically have pipes that are consistent, and they haven't seen the same kind of innovations that the internet industry has seen. Therefore, these pipes don't need to scale the same way that the internet industry sort of probably, or the telecom providers or broadband providers need to scale their pipes, or their demands keep changing. And so that was the argument used to sort of suggest that this should not be considered a public utility, and should more regulatory burden on them would prevent sort of them from foreseeing what the demand is and making future investment in the infrastructure itself. The next argument that they made was the biggest proponents of net neutrality are often the edge providers or the content-based providers, who
Those are the Googles and Facebooks and so on.
Googles and Facebooks and so on, who themselves use paid prioritization as a business model. They often put content in front of eyeballs, and they sort of thrive based on that business model. So that was the other argument that was used, that they use it. So they were talking about regulatory parity. So your Googles and Facebooks use that model, whereas your ISPs or your telecom providers sort of are not allowed to use that. So they were so one of the reasons why they wanted to move it back to Title I or reclassify it to information service carrier services is to sort of bring in that regulatory parity. At least that was the argument. And the final thing I wanted to touch on is, of course, the other argument is that they have seen more competition in the industry. So one reason for actually moving into the Title II is like in the telephone industry, which was sort of a natural monopoly where you had high fixed costs and large economies of scale. In the past years, you have sort of more competition in the industry, and that was another reason for them to sort of suggest that Title II was not really necessary. Even the light touch Title II was not necessary. Now, on the mobile side, they sort of took it a little further, and they reclassified mobile broadband from to a private mobile service. They completely moved them from the common mobile radio services to a private mobile service. And their argument there was that mobile services didn't actually, to be classified as CMRS, they needed to actually...
Again, so what is CMRS?
The common mobile radio services
Commercial
and
mobile.
Commercial mobile radio services, and they sort of needed to be they sort of needed to provide interconnection between public switch networks using the North American numbering plan, which these mobile services don't. They use IP addresses. So that was the argument to sort of suggest that maybe we shouldn't subject them to the CMRS rules anymore and move them into move them into the private mobile service category. So that was, I'll talk about the mobile argument in terms of competition from the proponents' standpoint in some time. But
a little bit of context on the mobile thing, right? That the FCC has regulated mobile internet access differently, separately from home broadband access, and the comparison between those two and analogies, arguments by analogy to the other one, are used a lot in discussing each of those policy areas.
Yeah, and on the economic side, it's important too because so on the proponent side, one of the arguments is over the last 5 years, about more and more people are giving up their because of the high costs of actually having access. It's harder for people to afford both a fixed service at home or a home service at home and a mobile service separately. A lot of people are actually cutting the cord there, and they just have mobile services. There are more households with just mobile services. And there is evidence that the the wireless industry is a highly concentrated industry, despite there being data saying most people have access to through your more providers. The HHI index, which sort of is the index to sort of that sort of tells you about how concentrated the industry is, for the wireless industry is really high. So there is evidence that the industry is highly concentrated, and therefore the proponents of net neutrality don't think moving mobile services to the private mobile services category is beneficial for consumers. So the other thing, so on the proponent side, they do view internet as a public utility simply because and you guys technologists filed a lot of comments to the FCC suggesting, just purely based on the technology and technological affordances, it's hard to call voice services Title II and call broadband Title I, because they're basically doing the same thing, sort of exchanging moving information from one point to the other. So it's hard to have voice. It's a bizarre argument to have voice under Title II and information service or broadband service under Title I.
And there were letters from prominent technical experts to the FCC saying that that the technical aspects of the analysis in the FCC's ruling were flawed.
Yeah.
And we'll be curious later to hear what panelists have to say about that issue.
And finally, I wanted to touch on the edge provider argument. So I talked about how the proponents of moving into that. So the argument that edge providers were using paid prioritization anyways, so for regulatory parties' sake, ISPs should be allowed to do so. So the argument over here for the proponents of net neutrality is that even though content providers do use paid prioritization for for ISPs, what happens often is, as a consumer, I have access only to one ISP. Generally, I'm subscribing only to one ISP. So when I look at content, it's coming through that one ISP. So if there is no net neutrality, I am basically going to see what that ISP is offering me. And when I'm paying for a service and I'm paying to be connected to the worldwide net, I want to see everything that there is, and not just what's being offered to me, what's being prioritized. So that's the basic arguments. And the other argument is that you're actually putting more power in the hands of edge providers or content providers, because now they are in a better position to negotiate, leaving the consumers more vulnerable. So that's the other argument. And on the mobile broadband side, I sort of talked about how, with the market being more concentrated, with more people using mobile network services, that's another area where they didn't even move it to Title III, which would come under the spectrum policies. There is no regulatory oversight over mobile broadband now.
So there's a lot of argument by analogy here, right? Is home internet service like mobile internet service? Is it like old telephone service? Is it like other utilities like water? Is it like Google and Facebook? And depending on which analogy you like, you can get to very different policies.
Yeah. And the last bit that I wanted to talk about is this whole notion of the fact that Title II might suggest increased taxes, especially because there might be a threat because of USF taxes. So in the telephone regulatory scheme, or in the past when telephone was regulated or is still regulated, USF money was collected in the form of small taxes.
USF is Universal Service Fund.
Universal Service Fund was collected in the form of small taxes from households. Even though the 2015 order really didn't imply that kind of tax was going to be levied, there was that threat, and that was used as another argument to sort of move away from Title II to Title I. And on the other hand, as we do away with legacy voice services and lifeline services, there is this whole question of what's going to happen to rural areas, high-cost areas that really still don't have access. And when we talk about all this data about a lot of the US has more competition, it's all the data that's being collected is at a census block level. Having worked on that data myself and collected that data when I was in Wisconsin, we realized we were collecting it at a census block level. And when you went into the census block level and you were drive testing, you realized even if a small portion of the census block had access, you would sort of say the whole census block had access, and not really. So it probably isn't a fair representation of how much is available. So that said, I wanted to conclude by just talking about the fact that the transparency rules still exist. I don't know if that will sort of help, but the transparency rules still exist, and the market forces sort of still could be like a reasonable threat against.
So the transparency
behavior.
rules require ISPs to publish information about what they're actually doing. So in principle, they are, say, blocking or deprioritizing certain kinds of traffic in a differential way, they're supposed to notify their customers about that.
Right.
How effective that is in practice, we could debate.
Yeah. And of course, states are preempt in this order as well, and the FTC has limited jurisdiction, but I'm guessing you guys can go more into the FTC's jurisdiction. Yeah.
Cool. So let's let Henning hit cleanup and clarify all of this for us.
So, obviously, a lot of topics already covered, so let me just try to step back just a little bit, to maybe start by giving somewhat of a historical perspective, as well as maybe a little bit of international perspective. You started with that already as to the kind of consequences. So the notion as to how we deal with communication networks is obviously, as you pointed out, an old one. This is not a new problem. And indeed, many of the problems that seem new, for example, the term network neutrality, really captures concepts, and I don't think Tim Wu would disagree with that necessarily, that in different forms we faced as long as we'd had private telecommunication networks. Well, first of all, we should recognize that the U.S. history is a very different one from almost every other country in terms of a development in telecommunication. Almost everywhere else, we started out with a government monopoly, typically the postal service offering telephones and telegraph service. And then maybe in the 80s, 90s, and sometimes even later, a privatization that occurred. And we also, in almost every other country, have had a fairly active, just simply because of necessity and because of a different political culture, a fairly active parliamentary legislative engagement in that. So either at the European level, at the European Parliament in Europe, or in national parliaments elsewhere in Japan or in Korea or in Australia and so on. In none of these other countries is the provision of broadband services considered anything except telecommunication. Right? There's just no argument about that. So we have to recognize that this argument that you kind of teased up is a uniquely U.S. argument. I mean, no other country that I'm aware of even thinks of internet access as anything other than telecommunication. So this whole argument that, indeed, the argument usually in other countries is, do communication services extend beyond the kind of a narrow confines? For example, would an email service be considered a communication service in that because it delivers information to the destination of the user's choice on a commercial basis? So you make an argument. But so we have to recognize that the U.S. is unique in its history and unique in its arguments that we're having. We're having debates that nobody else is having. We're just not unique. I mean, we do that in healthcare. We do that in public transit. So, and we just have to recognize that we should look sometimes beyond the borders to see that this is an argument nobody else is making. And indeed, you could argue that in none of the U.S. companies in other countries where they are the beneficiary of, for example, access to the local networks, have ever made the argument that these local monopolies or local legacy carriers, dominant legacy carriers, should not be regulated in that way. Historically, like I said, we've had, since AT&T became the dominant carrier, starting kind of around the turn of the 20th century, we've always had two type of fundamental questions. Namely, one is, how should that dominant carrier be treated? And towards consumers, and what obligations do they have towards other kind of ecosystem participants? So this is the interconnection argument. Indeed, kind of what is a landmark notion that essentially was AT&T's attempt to get out of being trust busted in 1913, what's known as the Kingsbury Commitment, which is a document which was signed by an AT&T executive when the administration at the time was looking askance at AT&T's attempt to essentially vacuum up all the many independent telephone companies that had sprung up elsewhere, particularly in rural areas, but also in the bigger cities in that. And so that commitment, which led to this long kind of regulatory history of largely a monopoly history, was one where, among other things, there was a commitment of interconnection. So that issue of interconnection as being of particular public policy concern dates back more than a century at this point. And it was always because AT&T, what they did at the time, was one way they would kill the independent operators, or essentially soften them up for acquisition, was that they would prohibit outright interconnection to their network, because AT&T was unique in that it both had a long-distance network, as you would call it at the time. Voice long distance just came into being and technically feasible, and they had local service in particularly non-rural areas. So interconnection has always been of a particular concern because it is an economic and technical choke point. And indeed, and this is where kind of it is illustrative to look at the arguments that the carriers themselves had made. There's been a long debate as to how you should charge for interconnection. So there used to be a history in the heavily regulated kind of heavyweight Title II era, that there were two charges. Namely, one is you would pay for a base fee to have a telephone in your home, and you would obviously pay for long distance calls. And then for incoming long distance calls, the carrier that originated the call and collected the fee from the customer at the same time would pay an interconnection fee, what is known as inter-carrier compensation, to the local carrier. Indeed, the rural carriers largely financed themselves, besides subsidies, out of those economic transfers. This was an indirect subsidy that the regulatory scheme had, where they said, hey, we basically make the urban guys subsidize the rural guys by paying a relatively high cost-based fee for terminating calls. Interestingly, starting in the 1990s and early 2000s, many of the large current carriers have made the argument that inter-carrier compensation is an inefficient mechanism for that. So Verizon in particular has been adamant about arguing that inter-carrier compensation leads to all kinds of bad behavior. Indeed, it does. For example, it led to, if you've ever wondered, the freeconferencecall.com, some of you might have used that. That is essentially a regulatory arbitrage ploy, namely a enterprising provider of conference calling and other services that are, let's say, not G-rated, decided that they would set up shop in small rural carriers. Rural carriers would get paid by the minute by inter-carrier compensation by the big boys. And so they could, there was a little kickback mechanism going on, so they would do what was known as access stimulation, and where they would essentially get people to call rural places which very few people would otherwise call to reach those free services.
So let's unpack that a little bit.
Yes.
Right? That if I call into freeconferencecall.com, my call gets routed to, if I remember right, some rural area in Iowa?
Yes.
Right. And my phone provider is required to pay that phone provider in Iowa a pretty substantial fee per minute for transferring that call. That rural phone provider then gives some money to the free conference call company,
Right.
which is how the free conference call company makes their money. So they're essentially, if you will, leeching off of my phone company.
Yes. And so it led to, whether you thought that was a useful service or not, it led to all kinds of economic distortions that were just not anticipated. And so the large carriers, and the FCC agreed, generally speaking, is that this inter-carrier compensation mechanism is very hard to get right without leading to these kind of economic distortions. And so there has been a trajectory, and we're almost there to what's called bill and keep. By the telecom carrier. That is kind of a model, is that instead of trying to find a fair price, the only fair price that people have ever been able to agree on is zero. In the sense that that's easy enough, kind of the old notion of computer science has 0, 1, and infinity. In telecom, it's essentially zero is the number. Everything else is very hard to not be subject to either economic power relationship, namely kind of unequal bargaining positioning, or to regulatory arbitrage. And where you basically have good intents go wrong, as in people leverage that in ways that were not intended, and then lead, and this is the other thing that I think is illustrative, is one of the consequences of the inter-carrier compensation was what's known as the rural call completion problem. Again, this is an indicator kind of historical prediction. So the rural call completion problem is that the big carriers didn't like paying the little carriers, whether there was free conference call involved or just generally. So they tried to find these so-called least cost routers that would get around those. And in many cases, the least cost routers, the way that provided least cost was not terminating the call at all. The cheapest call you could make is the call that just keeps on ringing. because you wouldn't know that when the call didn't complete, and there's all kinds of reasons why people don't pick up their phone after all. And so you now had this rural trade-off that got congressional attention, all of that. So the consequence of that, again, this is, I think, gives us some indication of what might happen, is that you now get, and this is where I think the notion you mentioned that rural carriers have the illusion that Netflix is going to pay them oodles of money for the privilege of connecting to some hamlet in Iowa, to just pick that same hamlet. Now, unlikely. What's going to happen is the version of the rural call completion problem, they're going to tell that hamlet to basically fly a kite and say, if you want Netflix, well, you either take it or you leave it. Namely, what happened, and you mentioned the interconnection dispute, is it was very clear that the only companies that had interconnection problems with Netflix were dominant providers. They were not, you would think, the ones that had trouble keeping up with Netflix traffic would be the small and mid-sized guys, the CenturyLinks and Windstreams and the small cable companies. They didn't. It was the Comcast, the Verizons, the AT&Ts that had problems because they could cause problems to ones, which actually magically disappeared as soon as it became clear that interconnection would be part of, within weeks, these impossible to solve technical problems suddenly evaporated. There must have been some magic technology that was invented, which was called ordering a new optical interface from CDW for a few $1,000s on their optical interconnect piece. And so that always has been a somewhat dubious proposition that the disposition of getting rid of network neutrality would somehow fund rural broadband in that. Simply the power relationships just aren't there. In that. I'll just, one brief one that I want to mention before I hand back, so to say, is we talk a lot, even here, kind of if you want to sound sophisticated about the network neutrality debate, you drop lots of Title I, Title II type of stuff. I want to point out that makes it sound like that there are essentially two paths of regulatory treatment, as when you can essentially, like a company which can become be a stock holding company, public company, or be a private LLC type of one, and you can choose, and there's a trade-off, and you can argue about which is better, but there are different ways of getting at the same thing. Nothing could be further from the truth when we talk about Title I versus Title II. Title II is indeed a regulatory regime, even if, as you pointed out, it is only applied in parts to both mobile services, which is basically the CMRS, which has before, and to residential and small business broadband services. Title I is nothing. This is not an alternate regulatory regime that provides some lighter weight thing. It is essentially a general mission statement, as well as a bunch of stuff about how the FCC is organized, that simply says the task of the FCC is to do to further the deployment of communication services in the United States, public safety, and so on. So it is a general mission statement. It conveys no authority whatsoever. It conveys, in particular, no regulatory authority in and of itself. This would get too long, but I'll point out that there was an attempt made, and you didn't quite allude to that history, in 2010, which was my first involvement with this particular topic, where the FCC, under the first chairman, under the Obama administration, Chairman Jankowski, tried essentially to thread the needle and pick a kind of Title I plus, or not really classifying things under a certain Section 706 authority, and the DC Circuit Court basically said, no way. You can't regulate a telecommunications service under this particular section, which is really more an exhortatory type of section in the Act, in that you either do it under Title II or you don't do it at all. So that model that is some kind of magic Title I that you could refer to is just not true. Basically, it now means that there is no regulatory authority whatsoever over any aspect, whether that's network neutrality, privacy, economic regulation at all, for telecommunication service providers. Just, again, I think that helps the argument as opposed to the notion that Title I is some magic tool that just is better in some sense.
All right, so we have complicated technology, complicated economics, complicated history and law, so before I open it up to questions from the floor, I want to talk very briefly and ask you guys about the role of competition here. Most Americans have access to maybe one or two options for traditional home broadband service. If you live here in Princeton, that's probably Comcast or Verizon. Maybe you have access to one of those, maybe both if you're lucky. But probably at most two, and I think a lot of people are in that situation. And a lot of commentators say that if we had much more robust competition in this market, if we all had, say, 5 really viable options to choose from, that we wouldn't need to worry much about this, that the market would take care of it. ISPs would not be able to engage in anti-consumer, anti-competitive games because then they would lose business to their competitors. So just let me do a sort of lightning round. Do you guys agree with this proposition that if we had much more competition, that this issue would be much easier? Or is there more to it than that?
So I think under the title or the new, there might be actually a harder for people. So people subscribe to a network. Subscribe to their ISP. It might be harder to actually switch networks because now, like you said, Title I doesn't really, there is no protection in place, so there is no regulatory oversight. So if the terms and services say, to break your contract, you're going to have to pay that much. There might be a huge cost.
Suppose we could arrange to have low switching costs as well.
So, again, then the whole thing of the eyeball issues. So it's only you subscribing only to one. So net neutrality from that point of view is still, if something's, you could technically switch, but there is a cost to switching. But if you lower the cost, I guess it could,
So competition and low switching costs maybe would be a solution if we could somehow cause it to happen.
So the other thing I wanted to add was for rural carriers, the other issue that smaller rate of return carriers are going to have is maybe access to poles and things like that with no regulatory oversight. It might be harder. Even 4 or 5 years ago, I remember small rate of return carriers sort of suggesting that the bigger, the price cap carriers or the bigger incumbents wouldn't let them access their poles, and that without any regulatory oversight, that might become a bigger issue. So I don't know if competition's actually going to.
Competition may be a lot harder to get in places with low population density, for example.
So again, internationally, when this is not wrong, is that we look at other countries and we hear that in France you can subscribe to whatever, a dozen different ISPs, at least in bigger cities. So they have somehow magically cracked this riddle of providing a large amount of competition. However, that is ignoring the central reason that there is competition. Namely, it's not that in Paris or Stockholm or Berlin they've somehow managed to string 5 different pairs of fibers to every home. No country has multiple fiber or coax or copper infrastructures to individual residences. It's a little different to businesses, larger businesses. That is not as uncommon. What has happened in all of those cases is that the reason you have multiple residential service providers is that the incumbent, typically because of a history, it's the old PTT incumbent, has a regulatory obligation to share its physical infrastructure with new entrants, which, curiously enough, Title II actually in one of the sections which was foreborn under the Net Neutrality Order would allow under the, again, this is interesting. I'll just add one historical tidbit to show that this is actually a change in that. The most recent change in telecommunication law, which dates back in its origins to 1934, and obviously did not mention the internet then, and was last majorly modified, so to say, in 1996, and indeed was passed with almost unanimous consent, including almost all Republicans. So the notion of infrastructure sharing, which is a core part of the 1996 Act, that's really, that 1996, the big issue was how can I get competitive local phone service? That was the big deal. And that was only, recognition at 96 was that you could only get that by forcing the Bell companies largely to share their wires with new entrants, so-called competitive local exchange carriers. And again, that at 96 was not controversial. It was like 96 to something Senate vote. I mean, this was about as unanimous as you can get. It wasn't easy to get there, but that wasn't the issue. So competition is not going to rise based on physical stringing wires. It is also not.
And the reason is it's incredibly expensive.
Right.
Wire is expensive, cable's expensive, and digging holes in the ground is
Right.
expensive.
And we've seen that, and this is a long economic argument, that in Google Fiber was seen by people who didn't understand the economics, and which is basically the argument that is there's more articles about Google Fiber than the Google Fiber customers, that they have that. And this goes to the economic investment argument, is that it is very easy for the incumbents in areas where there's a threat of competition, since you just can't show up with a spool of fiber and say, hey, I'm going to just offer, like you can do a grocery store. We can, within a month, you can be a new entrant and open up a fancy new grocery store. It takes years to be a competitor, so you can lock down your customers in various ways I won't get into. Pole attachment being one of those, so that a new entrant can essentially be bled to death. And this is one reason why Google got largely out of the physical fiber business, because they have to compete in a limited number of places at any given time. So the incumbent can lower prices, provide better service, do investment. Indeed, the biggest predictor of investment has been general competitive intensity, not deregulation. And AT&T and Comcast invest in places where they face competition, not in places where they face no competition, in rural areas being one of those.
And there are certain rural areas where they don't even go into. It's only
Right.
the reselling that's helped bring service to those areas.
Cable companies
Yeah.
generally don't serve rural
Yeah, yeah.
areas for historical reasons
Yeah.
as well as just practical reasons.
To come to back to your question, what might competition change? I'd like to sort of talk about two things. One is interconnection. So this thing we've been talking about, Comcast connects to Netflix and who pays who, which is actually, when I went to the FCC to explain to them how interconnection worked, that's pretty much the only question they were interested in. Forget about BGP and all these boring internet routing protocols. Just tell us who should pay. That's a much harder question, as it turns out. This idea that someone's got content and someone's got eyeballs, and somehow we've got to move the bits across, and someone needs to pay for that, is, as you put it, it's not a new problem. This has basically been going on since the commercialization of the internet in the mid '90s, and to the telephone network before that, apparently. Generally speaking, peering agreements kind of work themselves out. There have been failures, market failures, you might say, in a number of cases. There are some pretty famous ones, but most of the peering arrangements you don't hear about because they kind of work themselves out. There's a book called The Peering Playbook where people talk about, okay, if Comcast or Netflix needs to send bits to Comcast, they've got some options. They can pay someone else to carry the bits there. It's called transit. Or they could work it out with Comcast and directly interconnect. And usually the calculation there is it going to cost us more to connect directly? Because there are costs to that, the fiber, the equipment, the et cetera. Or should we each respectively pay someone else to help us get the bits there? And if directly connecting is cheaper, we'll do that. That doesn't answer the question of who pays who in that situation, right? So now you've got a dynamic of, okay, transit, I have the option of paying transit. That's going to cost me some money. Or I could directly connect. That's going to get me better performance. But now I've got to fight about who pays who. And your question was about competition, right? So if the only way to reach subscribers in your favorite rural town is through this particular ISP, then Netflix has a pretty, the ISP has a pretty big lever to say, okay, you're either going to connect with us and you're going to pay us to do so, or you're not going to connect to us at all. And it's at that point where the ISP can use its market leverage
So
to
the one
extract.
who's in the less competitive market is
Right.
likely to be the recipient
Right.
of payment.
Whereas if Netflix had an option to get to those eyeballs, to say, okay, well, if you're going to charge me to reach those eyeballs, I'll just go over to ISPB here, and because they'll let me do it for free, then now you've got a negotiating position. And part of the issue there with lack of competition to the eyeballs is that the ISPs have a very strong negotiating position in those peering arrangements that, historically have worked themselves out. But in this case, we have you might call it a market failure due to lack of
I mean,
competition.
I'll just interrupt briefly and say that we've had this similar type of discussions, and this actually played out a little differently than you say in what's known as retransmission disputes, where you also have distribution content, namely your local TV station, and distributors, typically a local monopoly cable company. And whenever you see blackouts, that happens on occasion where suddenly it says, sorry, you get big newspaper, it used to be, you don't do that anymore, presumably, a newspaper advertisement is the other guy's fault that you're seeing a black screen when you tune to Channel 7. And this is a version of the same problem,
Yeah.
and it's not obvious that the rural guys actually do have the leverage there simply because Netflix is going to put up a big TV advertisement on Dish and say, the reason that you can't watch your favorite Netflix show is because the evil ISP won't do the right thing.
Right.
So,
Right. Great. So let's open it up to questions. Scott.
So related to this, and maybe you can clarify, is I remember several years ago this idea of opening up the infrastructure as it specifically applied to DSL service. But there seemed to be some shenanigans that were going on that, for instance, if a particular company had the infrastructure but also provided the service, because they maintained the physical infrastructure, if you had an alternate DSL provider and said, hey, I'm getting static on my line, I'm having trouble, those tickets sometimes got slowed down or lost in the system, and it put those other people at a disadvantage. Am I remembering this right?
Yeah.
And how does this get solved? And
so
dealt
there's
with?
actually and this may be apocryphal, but it is too good to check, as they say these days. Namely, this is the toilet story. Namely, when the CLECs came into the competitive local exchange carriers, initially for voice, but they quickly, like Earthlink, pretty quickly discovered that really what was a business model was providing DSL services first to residential, and which is what they're still doing, not residential, is small businesses typically. Is under the 96 rules, until those essentially got weakened, they had to provide access to that. What they also said is, well, you have to get to the central office to actually install your equipment, your DSL, your DSLAM, in that case, for that, to make that happen. Well, the rules don't say anything about parking. They don't say anything about access to the toilet facilities on premises. And so what would happen is that the local bell company would make it as impossible, leaving double tickets aside, as difficult as they possibly could by whatever the lawyers thought they could get away with, to provide equal access once you actually made it into, didn't have your truck towed, to provide access to the facilities. So that's always been contentious. And this is one reason why the CLEC model, with few exceptions, has not been terribly successful. So there is a reason, and then I will say that, and this is a larger debate than the net neutrality debate, is that the model worked relatively well in Europe because you had a strong regulator and largely a DSL-only infrastructure. I mean, a few European countries have lots of cable, TV, but most of them don't. And cable typically does not have equal access. Coax cable does not have equal access, and fiber often does not. So Europe actually will have to struggle with many of the same issues as to how you encourage fiber investment and how do you deal with fiber equal access 10 years from now, roughly, when copper is no longer an option. Europe had the advantage that copper loops are shorter, so they could provide higher bandwidth than the US can for the same infrastructure, but the issues are similar. I mean, this is not an easy problem in general to provide competition even under those circumstances.
Yeah. Joanna.
I had a question going back to what Castillo was talking about with respect to the utilities. So I have to admit that I'm not entirely keeping up, but people ask me sometimes, isn't artificial intelligence isn't going to become a utility? And I don't know what they're saying. And going back to what Ed was saying before about that you could be talking about these 4 different metaphors, I think sort of what they're saying is that they're putting Google and Facebook into the water category as something to depend on or something, and that's the only thing they're saying. So could you just, I'd just like to hear you improvise, if not off of what I just said, off of what Ed said. Is there a way to collapse some of these metaphors and say whether any of them actually apply?
Or under what circumstances would it make sense to treat a technology product like water or electricity
More data.
as a regulated monopoly like those services are to some extent?
To large like the economic argument behind what you can call a public utility and what you can't is largely the cost, the high costs of actually, providing, building it out. Like that's why monopolies or oligopolies typically exist in those markets, because they're high cost. There's a lot of high cost to just sort of set up the infrastructure,
To run the pipes. for
And
example.
then it has large economies of scale. So once you've done it, the economies of scale set in, so they like you were saying, they can sort of hold out another entrant because they can hold out another entrant. So it's harder for other competitors to enter that market. So traditionally, those were the kinds of industries that fell, and it had to be an essential service to for it to come into the
So
public.
it does
Yeah.
kind of sound like Google.
So an essential service, high fixed cost,
yeah.
and high fixed cost as a barrier to entry.
Yeah.
Those are the conditions?
You could probably fill in the gaps here for me too, but there's, beyond the word utility, there's specific definitions that the lawyers will argue about: the information service provider, which is Title I, versus the telecommunications service provider.
That's
Yeah.
and this is an important
and-
distinction, right? You can be talking about this in the structure of telecom law,
Yeah.
which is very detailed and technical, and it insists on drawing lines that might not make much sense from a technical
so
or
I was going to
economic
give
standpoint.
one example, and then maybe you can.
Or you
sort
could
of
be talking
correct.
about what
Yeah.
an entity like the FCC ought to do if
Right.
it could do whatever it wanted. And as
Right.
Henning and I were discussing earlier, having both been chief technologists at government agencies, the difference between doing what makes sense versus what it is that the law allows you to do,
Yeah.
and the distinctions that it forces you to make, those can be pretty different.
So I was reading the order that came out last Friday, and it gets to exactly this point where it's not clear, like things fall on one side of this line or another. I won't try to recant the definition of information service, but it involves things like benefits to consumer and mangling of bits in certain ways. And two of the things which the subsequent orders seem to take opposing views on are ISPs. They provide a service called DNS, like they map domain names to IP addresses. So when you look up google.com, you get an IP address. And they also do caching, right? So they'll basically take content and they'll basically put it in servers closer to you so you get better performance. And there appears to be disagreement, depending on what conclusion you'd like to argue or arrive at, as to whether or not DNS and caching make an ISP an information service provider or a telecom provider. And the current rulemaking from last week says, these guys basically provide these services which primarily benefit the consumer, and therefore it's you shouldn't be calling the ISP a telecom provider. If you look at something like DNS, it's actually not on one side or the other. Sure, it provides benefits to the user, but also the ISPs use it to
These
manage
are
the
things
network,
that
so-
don't fit neatly into
Yeah.
either of the categories that
Right.
the 96 Telecom Act
Right.
requires you to cram everything into.
So you could use something like that and argue all day long about which side of the fence that is going to sit on.
Yeah, so, and again, I'll raise a historical argument, because what's often missing is that while the internet is new, many of the issues of classification, for example, when I picked up a book that you can get online, if you have a library, which dates back to the early 2000s about classification of various parts of a traditional telecom network. And there, the issue's always been that you had essentially all modern networks past kind of the earliest communication, like kind of mechanical switches type of thing, have had two components. Namely, they've had the actual transmission component and they had a control component. If you teach networking, if you teach historical networking, you talk about something called SS7, signaling system number 7, which actually indicates this was certainly not the first attempt at that. And that consisted of databases, among other things, that were, indeed, this is where Unix came from, was large. One motivation was that AT&T developed it was not just to be computing. They wanted stuff that ran more modern in the 70s in modern networks, indeed, and do number translation. Yep. Your 800 numbers are, if you kind of look at them a little differently, are nothing but names that get translated like domain names, because like 1-800-Flowers type of thing, to a underlying geographic telephone number in that. So, yes, this has been an argument that has been around forever, and one of the problems that you have is that, and this goes back to a regulatory one, is that clearly the court has said that the previous FCC interpretation of congressional law and intent, so the Telecommunication Act in its 96 version, and intent as to what was actually discussed at the time was well within its reasoned decision making in that. So it wasn't like you could argue that was bad lawyers, so to say, or overly aggressive lawyers. So the interesting question really would be one, and this is one that is hard to predict, is, and this goes back to an old Supreme Court decision on this Brand X, where in the early days, I won't unravel this because it will take too long, but where my non-lawyer take is that basically the Supreme Court said this is complicated, we're not engineers, the expert agency, which is what the FCC and other agencies like the FAA and the FTC and so on are referred to, they in the end get to make the call because it's complicated, like you said, in that. So it's certainly, if the FCC, you cannot make the argument, the honest argument, that the FCC is legally prevented from doing that because until the Supreme Court says otherwise, the highest court in the land that has ruled on this issue had said that the FCC was well within one, because it upheld the 2015 order. That's one piece that we kind of, the courts got involved in a few cases in that. So the question really will be going forward is, within essentially 2 years, can the FCC change its mind on the same subject matter, and is that within kind of reasoned decision making that it can basically, never mind, politics have changed in that, and we can just do the opposite, and both are okay.
So most likely it will be these legal questions that determine how the net neutrality policy plays out over the next couple of years, right? With all of the legal challenges now backed by some of the biggest technology service provider companies against the FCC, challenging the FCC's recent action, will the FCC's action stand up in court, or will it be overturned and put the FCC back to square one, as happened with the 2010 attempt to impose net neutrality regulations? The only thing we can say for sure is that there will not be a shortage of lawyers working on that issue. So with that, we will dismiss you for some non-discriminatory access to food and drink in the back of the room, as well as an opportunity for peering and interconnection. So please join me in thanking the panelists.